Go ahead and get started. Once again, if you haven't signed in, please do so. This course does count for Vermont CLEs. If you live in a different jurisdiction, you need to do that through your jurisdiction. Please, once you sign in, we will email you the materials. There is a printed packet with the slides, but we'll definitely send that out to you. We're required to have a paper here, and then there's also a bio for our speaker. So without further ado, Lou Helmuth, and I hope I'm pronouncing your last name correctly. Lou Helmuth, class of 1984, is here. Welcome.
Thank you. Yay, class of 1984. Thank you very much, everybody. I am Lou Helmuth. I am from the class of 1984. You can all do the math. There's a bunch of you in the room here. 40 years since we graduated from Vermont Law School. This wasn't even a classroom. There's all kinds of stuff that wasn't here in those days. But it's wonderful to be back. I have had kind of a crazy or just varied legal career. After law school, I spent 15 years or so running my own, what we call the private public interest law firm, representing students with disabilities relative to their educational need. It started in Burlington. I then moved to San Francisco, and we established a bi-coastal practice because we were representing kids with disabilities in these pretty complex cases against school systems, big trials, like 3 weeks, expert witnesses, all kinds of stuff. People kind of couldn't afford it, right? And I was like a 25, 6-year-old something lawyer, along with my partner, Greg Van Buiten. And so we did that litigation sort of around the country because there were very few lawyers who would do those cases for families. And, you know, we were like, wow, $2,000 came in. You know, the bill should have been like $102,000. But at the time, it didn't really matter to us. So I did that for a while. Greg sort of stayed in Burlington. We had a number of lawyers here. I was in actually Sausalito at the time. And one thing led to another, and things kind of disintegrated happily, sort of. And during that time, I experienced some sort of dismay with some members of the bar. Thought a lot of people were kind of miserable and mean. And so I wanted to see if I could impact that in some way. So I decided I need to get into legal education. And so I was like, well, I could teach. You guys will all be able to verify in about 40 minutes that I am unable to teach. So, so I realized that was not going to be an option. I got into the professional development world in law schools. I first started at UC Hastings in San Francisco for 1 year. Then I went down to California Western School of Law in San Diego, which is another independent law school, just like VLS. There were 14 at the time. I don't even know how many there are right now. So that was kind of an interesting, another about 15-year segment of my life. And then I was like, I don't know if I could see on my tombstone, like, Assistant Dean for Professional Development. I just didn't want that as my punctuation. Not that there's anything wrong with that, but I didn't want it. And, you know, I came to Vermont Law School to be an environmental lawyer. And one thing led to another, and thank goodness I didn't get the judicial clerkship at the Vermont Supreme Court, because goodness knows where that would have led me. But I, you know, found myself wanting to get back to environmental law. During the time when I was working at the law school, I did a number of pro bono cases. I fought a couple of quarries here in Vermont. I prevented the paving of a municipal park in San Francisco, right? Representing little citizens groups, like while I'm the assistant dean and I'm doing this kind of cool stuff like environmental law, like I wanted to do. And so then, you know, I was looking around for something else. My wife is in the performing arts. We got very active in the nonprofit world. One thing led to another, and I started going to the PILC, Public Interest Environmental Law Conference at the University of Oregon. Do any of you know about that? Yeah, several people. It's the coolest thing in the world, right? I mean, if you're like at all a greenish lawyer, it's your tribe. And it is really one of the most substantive, professional development conferences I've ever been engaged with. So I started kind of going to that to juice myself up a little bit. And I walked into a room just like this. I sat in the back, and there's this woman named Julia Olson who's sitting here, and she's got like 3 teenagers next to her. And they start talking about the thing that I'm going to talk about today, which is our children's trust. That was in 2011 when I saw Julia and the kids. And the long and short is that our children's trust is a nonprofit law firm. And we do, I'm going to say I retired just almost 1 year ago. You're going to hear about a really spectacular Montana case that we were involved with. I retired just a couple of days after we finished that case. So our Children's Trust represents young people and supports young people in litigation around the globe, suing governments to effectuate science-based climate policy on national, state, and quasi-global or global domestic levels. Wow, what? At the time when I met Julia and the kids, these cases were grounded in the public trust doctrine. So the public trust doctrine is an ancient doctrine, Roman law, and it basically says that, we have natural resources and they're finite. We think, I don't know how deep you can dig or whatever, but we as governments and Roman emperors understood this, and the Roman civilization understood this, that we have these natural resources and we have to use them and protect them for ourselves, but also for future generations. We have a public trust obligation. And so at the time, these cases were grounded in the public trust doctrine. Government has a responsibility to protect a natural resource called the atmosphere, right? And as a result, we need to protect that. We can't denigrate that. And right now, with environmental policy, fossil fuel development, and everything, we are denigrating that natural resource. We are not protecting it for future generations. So we're violating the public trust doctrine. So that was our first case, Alec L. That was a federal case. Okay. And there's a whole long story. I guess I have to say this too. Shortly after I met Julia and the kids, Julia Olson is the founder and still chief legal director or chief legal counsel for our Children's Trust. And at the time I met them in February, they were just about to launch a spate of legal actions around the United States. It was Mother's Day 2011. Our Children's Trust filed 50 legal actions on or about Mother's Day 2011. A bunch of rulemaking petitions in a lot of states, a few state court actions, one federal court action in California, in the Northern District of California, and that was the Alec L. case based on the public trust doctrine. All of these other proceedings were also grounded in the public trust doctrine. And the long and short is that of those 50 actions, several of them were just ignored by various states. I wasn't even formally involved at this time. So it's like Julia and Elizabeth, who was a law clerk, and the kids. Right? Also supported, and I have to give a shout out to Professor Mary Wood at the University of Oregon, who is sort of the brains behind the atmospheric trust doctrine, right? Protecting the atmosphere with the public trust doctrine. So that's a stretch, right? We have the public trust doctrine, but now we want the courts to apply it to the atmosphere, right? That circles everybody. It's not just the river right here or anything like that. So, that was the big stretch. So we go to the Northern District of California. We sue basically everybody, all federal agencies under the sun, right? And those federal agencies say, oh my God, it's so far to get to San Francisco. we want to remove the case to the District of Columbia. So the case got removed to the DC Circuit. And we got dismissed quickly at the district court. We went to the Ninth Circuit Court of Appeals, and some judge, what's his name? Merrick Garland. Merrick Garland, thank you. Believe it or not, right? Merrick Garland's the chief judge at the DC Circuit when we were there, and he signs this like 1 page, like totally like disheartening, dismissal of our case, right? It's like you can tell we were all pretty excited, right? So Merrick dismisses the case. We file for cert and don't get cert, right? Alec L. done. Little weird, just an aside, because things morph. You notice public trust isn't in there except for the name Our Children's Trust. It's constitutional stuff, about to make the transition. The analysis of the courts was that the federal government doesn't have a public trust obligation, right? It just doesn't apply to the feds. It's a state doctrine, right? Even though they use that to justify declaration of wilderness areas and otherwise, right? So it's just, you're gonna hear about a lot of, yes on the law, no on the law. Remember Professor Bischoff? Maybe yes, maybe no, right? That's what we got throughout and still are getting to this day. So I remember Julie and I are walking on Fort Funston in San Francisco. I'm sorry I'm doing all this, but one of my classmates, Barry Bram, and his wife Mary are here from San Francisco. And so we're like, what are we going to do? Like, we have to remorph. Like, and I'm like, Julie, what do you want to do? She's a brilliant woman. If any of you have the opportunity ever to meet Julie Olson, she's got a beautiful heart, a brilliant mind, and a wonderful advocate for children. I'm going to cry. We got to change this up somehow. We can't just rely on the public trust doctrine. We just got slammed. All these other cases are percolating, right? Some of them rulemaking, a little bit of attention. Some of them rulemaking, a little bit of attention, denied. Now let's sue them. We've exhausted our administrative remedies, right? Let's do that. We can now get a case going forward. This one's like ripe and ready, but the kids are like not like organized enough to like be good plaintiffs in a court case of this magnitude. So a lot of different factors went into which cases are going to move forward in this campaign. So that's the general bailiwick that leads to the constitutional efforts that are grounded in the fact that the climate crisis is the biggest driver of the health of every child born today. It's just a fact. Public health officials agree. It is, if there's one thing that is going to impact a kid who's born today more than anything else you can be guaranteed of, it's the climate crisis. That's Aji Piper, who is one of the Juliana plaintiffs. You'll hear more about them in a minute. So all the work that we do is all kids, right? That's we only represent kids, except some of those kids, the Juliana plaintiffs, like Kelsey Juliana right there, she was 14 when the case was filed. Now, 9 years later, she's 23, so she's no longer a kid, right? But Avery McCrae over there on the left, she's still barely a kid. I think Avery might be 19 now. Chutesca Martinez right there. And then off to the right is a member of Congress whose name escapes me right now. But that's in front of the Supreme Court during one of our efforts before the Supreme Court, doing press conferences when everybody's trying to shut this stuff down. All the cases that we do are for science-based and legally enforceable systemic remedies. All of the defendants are governments, okay? And we consider all of this grounded in basic human rights principles. So who are the players? Youth plaintiffs. Everything that Our Children's Trust does is guided by, driven by, and directed by our youth plaintiffs. I don't know, maybe not for any of you, but for me, when I first got to Our Children's Trust, something happened and, I forget what the event was, and we needed to put out a press release. And I was like, Julia, I will write up some, talking points for the kids. She's like, what do you mean? And I'm like, well, for the press release. She was like, no, the kids say what the kids want to say. And it is true. Like in the media, we get a lot of, we're manipulating these children and we drag them into these lawsuits unknowingly and things like that. You talk to any of these kids and they will, belie that or deny that or belie it, I guess. They are central to and most important to everything we do. There's a staff now. When I joined our Children's Trust, there were 4 of us. Now there are like 30 of us. We have lots of cases, which you'll hear about in a while. A couple of federal cases, a bunch of state cases, cases in other countries that we guide and lead and work with local counsel. So they are critical to our efforts. Is Dean Rushlow in the room? No? Okay. I'm sorry. The 2 of you, I don't know her personally, but you're smiling, you're nodding your heads, and I was just wondering if maybe one of you were Dean Rushlow, who was one of the local counsel in our Massachusetts case. Pro bono testifying and consulting experts, including Nobel laureates. The world's best experts have come out of the woodwork to support these kids. Scientists, geologists, everybody, medical professionals, the whole 9 yards, all pro bono, Nobel laureates. It's remarkable. And the amount of time and effort that they have put into these cases, you'll see, is remarkable. And amici and partners, like the number of people who have signed amicus briefs, and youth scientists, members of Congress, surgeons general, legal experts, indigenous leaders, like all sectors of civil society are participating in these cases in one way or another. So as I said, all these cases are science-based. It's not going to turn into a science lesson, but to be very quickly, the basic science that's critical to us is that we acknowledge that concentrations of carbon dioxide right now are at about 422 or 423 parts per million. And that's why we have a climate crisis. Okay, because of the greenhouse gases and largely carbon dioxide in our atmosphere. It's at 422, 423. 350 has been determined by some of the world's best climate scientists, including Dr. James Hansen, who's a remarkable guy who some of you may recognize the name of. If not, Google him. He's been fighting Al Gore is like the hockey stick climate, politician. Jim Hansen is the guy who has been fueling that. And Jim is the guy who has really, he determined this 350 because we needed a legal standard to ask the courts to meet. We couldn't just say, how do you fix the climate crisis? So Jim and his team, he used to be the director of NASA's Goddard Climate Center. And he determined that if we can get carbon dioxide down to 350 parts per million from where it is now 422, we will start stabilizing all the disruption that we're seeing in our climate. The extreme temperatures, the extreme weather circumstances, the coral bleaching, all the stuff that we all know about. If we can get down to 350, things will be okay. They were at 350 at about 1983. That's the max, 350. The sweet spot is really 280, which was pre-industrial revolution. 320 would be nice, right? But we got to get to 350. And we have to get to 350 by the year 2100. That's the magic formula. 350 parts per million carbon dioxide by 2100. And if we can do that, right, we will stabilize our climate system. And children will have futures not fraught with what they are fraught with today. So everything is science-based, youth-focused, and then we seek systemic solutions. Talk more about that in a moment. Kids have been at the forefront of social change forever, right? There's all kinds of efforts. Sylvia Mendez was a young woman, a young girl of Mexican descent, early 50s, led the effort and got a court order that they had to desegregate schools in California, right? 15 years old. She's the kid who stepped up and did this, right? Claudette Colvin. Does anybody know who Claudette is? She's cool. Claudette was 15 years old. Remember Rosa Parks? Remember how Rosa Parks was like, I'm allowed to sit on this bus? Claudette Colvin preceded her in that effort. Claudette was 15 years old. She was like, I'm not getting off this bus. It's my constitutional right to sit right on this bus wherever I want. 15 years old. She did not, they say, you know, the pundits or whatever the internet says, you know, that she didn't get the credit, if that's what you want to say, because she was a light-skinned woman. Her hair wasn't right, you know, according to the standards of the day. So all kinds of ridiculous prejudice. But this young person stood up, became like Rosa Parks' inspiration, and the two of them, you know, continued to be colleagues. Birmingham, 1963, when Martin Luther King, you know, made the controversial decision to use students at the march. But it was the fact that kids were jailed, kids were fire hosed, dogs were unleashed at kids that got the world's attention on this, right? So the power of the youth voice in social change movements in our country and around the world, in fact, is incredible. And today, this is Claire testifying at the only trial we've had so far. It's happening today, right? So we really believe that children are central. Their voice is central. Their plight is central to swaying judges who have to make these bold decisions to remember what we're asking them to do. Meet this scientific standard. In order to get from 423 to 350, it's possible. We've proven that it's possible. We have experts who testify to it. And this is a way oversimplification, but basically what we need to do is electrify everything by mid-century, right? And fuel it with renewables and sequester carbon in, you know, the second half of this century, which is now 25 years away, right? We do not have a lot of time, but it is completely doable. So we have the Merrick Garland situation, federal court. Julie and Lou go for a walk on the beach, gotta go bigger, gotta go constitutional. And we file Juliana versus United States. This is like, it used to be the signature case until the Montana case went to trial and we won that, which you'll hear about in a moment. But Juliana is huge. And 21 kids, they're fabulous kids. You know, they were little kids at the beginning and now they're adults. This case is grounded in the following premises. Affirmative government actions that are known to exacerbate the climate crisis violate plaintiffs' rights to life, liberty, property, personal security, and equal protection of the law. They also violate the government's obligation to protect natural resources for the benefit of future generations pursuant to the public trust doctrine. Now, you know, we're in the Ninth Circuit now, no longer in the DC Circuit, so we can raise that public trust claim again. You know, everybody gets involved, fossil fuel trade industries, the Petroleum Institute, everybody intervenes in the case. It's a big hullabaloo, there's all kinds of stuff. And let's see, we filed it on August 15th, 2015. So this is a year and 2 months later, after several motions to dismiss, Judge Ann Aiken, by the way, Juliana was filed in the US District Court in the District of Oregon. Our Children's Trust is based in Eugene, Oregon, where that fabulous public interest environmental law conference is located. And we brought the Juliana case in Eugene, like down the street from where the office is. And Judge Ann Aiken is the chief judge there. And she ruled completely in our favor in a really stunning decision. Okay, like I really liked it, but you know how you can read some decisions and they're just really nicely written. It's like a book, right? It's a nice story, but it's not really well written. It's just beautifully written. And and it says all the right things. So Judge Aiken says, I have no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. So she finds that a climate system capable of sustaining human life is a fundamental right. Right? Where a complaint like ours alleges government action is affirmatively and substantially damaging the climate system in a way that will cause human deaths, shorten human lifespans, result in widespread damage to property, threaten human food sources, and dramatically alter the planet's ecosystem, it states a claim for a due process violation. Right?
I think I read this semester in Vermont Law School, and it was like, like a week after the election. So this was something that was really chewing me up at the time.
Exactly. Good point. This was right after the election. And remember, at the time, this case was against the Obama administration. So yeah, it was an important time. Thank you for reminding me of that. We're going to get to a timeline. Next slide. But this is what we've always understood about these cases. We can prove all of these elements without any controverting evidence. Like, it's particularly if you're talking preponderance of the evidence, like, oh my gosh, we can go beyond a reasonable doubt. It's like, if we can get to trial. So these governments are doing everything within their power to keep these cases from going to trial. Why? Ann Aiken actually said to the US DOJ once, she's like, when it's the Obama administration, it's before this decision, she said, wouldn't you like me to rule in the kids' favor? Wouldn't that give you license to enact and do the climate policy that you want to do, right? And they just kept fighting. Why? Here's Lou's theory about this. Not that Lou's theory matters about anything. Ask my wife. It's true. But I just feel like no governor of Hawaii, who you'll hear about in a moment, no governor, no president wants responsibility for putting into action the systemic kinds of changes that are going to be necessary to draw down carbon dioxide from 423 to 350 by 2100. It's a heavy lift. There's going to be all kinds of complaining people. We're not going to change life, dramatically. It's like everybody's got to wear a seatbelt now. Oh my God, it's going to crinkle my shirt, make my shoulders. People get used to these like little behavioral changes that will come from this, but there will be a lot of grumbling, and no executive wants that on their watch, right? So that's Lou's theory. This is a truncated version of the procedural history of the Juliana case. In the sort of the first color blue, that like lighter or that sea blue, those are district court proceedings. Bright blue is Ninth Circuit Court of Appeals. Green is Supreme Court. And this is not 25% of it. File the complaint, motion to dismiss, deny, right? They move for an interlocutory appeal. The trial judge is like, no. You need permission of a trial judge to get an interlocutory appeal. Ann Aiken is like, no. The federal government files a petition for writ of mandamus. Anybody know anything about petitions for writ of mandamus? You do? Awesome. Want to give me what you know?
Basically suing the judge.
Yeah.
The judge has responded. The judge who's you're petitioning the higher court to replace the judge. The judge has to respond or hire counsel to respond and explain why he or she is fit for the case.
Yeah, because that judge has done something so egregious, and there's no other remedy for the government that we must have a higher court come in before final judgment, when we could just appeal the whole darn thing, right? So it's some egregious behavior. And the egregious behavior that they're complaining about is her decision on the motion to dismiss. It's just it's an opinion of a court, right? Appeal it, go to trial, maybe you'll win, right? Who knows? So Judge Aiken fights it. They file this motion for a petition for writ of mandamus. Really interesting thing. US DOJ manual, guidebook, something like that, requires that the United States Solicitor General and the United States Attorney General sign off on DOJ's use of a petition for mandamus. Like, these aren't the line litigators who are making these decisions. This is Top Gun stuff. And in this case, spoiler alert, they filed 7 petitions for mandamus in this case. It's unprecedented. We know of no case in the world that comes even close. That's how much they want to stop this. This gentleman's telling us it's already like a bit of an unusual thing to be suing the judge. Like, what are we talking about? And this is just based on her decision on the motion to dismiss. Mandamus, they lose mandamus at the 9th. They go to the Supremes, right? Meanwhile, we're getting ready for trial on October 29th, 2016. 2016. No, the decision was 2018. And so if you look in this middle section here with those green things, first of all, there's one SCOTUS petition, petition for writ of mandamus to the United States Supreme Court. They said no, right? Justice Kennedy was like, I don't know, it seems like a big case, but no, that's an extreme remedy, right? And then 10 days before we're going to trial, we are so ready for trial. Tickets purchased for experts. Everybody's lined up. All depositions taken. Kids have been deposed. Kids have cried during depositions. All kinds of stuff. And they file the second stay 10 days before. The next day, as I recall, it was Chief Justice Roberts issued a temporary administrative stay on the 19th, and our trial was off. Right? This huge trial. And then 4 days later, they lifted the stay, right? So, the whole thing is now off track. 4th petition for mandamus, just all kinds of stuff. Crazy, crazy procedural nightmare. So check this out. Oops, I'm sorry. So this is Eric Grant on the right here, and I hope I'm going to be able to get this to play. He is the Trump appointee. So as this gentleman pointed out, Trump is elected. 10 days later, Ann Aiken issues this fabulous motion or decision on the motion to dismiss, and then Trump comes into office, and this guy, Eric Grant, becomes the Trump appointee who leads the DOJ ENR, Environmental and Natural Resources Division. So he's in charge of all the cases that are in ENR. We never wanted our case in that. We wanted it in the Civil Rights Division, but it landed here. So this guy comes in, and I'll give it one more try, and tell me if you can't hear it.
Litigation for kids, the case of Juliana versus United States. I was told to avoid giving you a mere lecture, and so I am going to tell you a war story. Like all good war stories told by lawyers, I am the hero of the story, although perhaps the unsung hero. Our story begins in 2015 when a group of 20 or so kids brought a lawsuit in federal district court in Oregon. In that opinion, the district judge basically held, yes, Virginia, there is such a constitutional right, and yes, I can enforce that right by ordering the president and 8 cabinet departments to cease doing some things and start doing other things, all with this goal about atmospheric CO2. And this is where I entered the story. You may recall another wild and crazy thing that happened in November of 2016. And that thing led me in April of 2017 to begin serving as the political appointee in the Environment Division of the Justice Department, directly overseeing all of the federal government's energy and environment-related appellate litigation in all courts save the Supreme Court. And my number one priority from day one was to kill Juliana versus United States. A mandamus petition is an extraordinary request for an appellate court to interfere in some way with an ongoing proceeding in a trial court. Even filing such a petition is rare, and having it granted is extraordinarily rare. If you, as a practitioner, file one mandamus petition in a U.S. Court of Appeals in your career, that's probably above average. It's just not things that you do. And the Ninth Circuit's opinion, 2018 opinion, denying mandamus goes through some of the statistics to show how rare that kind of relief is. And for us to have to file 4 in the Court of Appeals and 1 in the U.S. Supreme Court, yeah, that's crazy. That's not normal.
So that's Eric Grant saying, my number one priority was to kill Juliana, right? Wait, what? Are you kidding me? It's like these kids in Eugene, Oregon, right? I mean, we're like the nicest people in the world. And he also says that mandamus is like wildly extreme, right? So in the interest of time, I gotta move us along. So they get mandamus, or they get denied mandamus. Ultimately, and for reasons I won't even begin to opine right now, although I'll tell you if you ask me later, Judge Aiken agrees to interlocutory appeal. The Trump administration was doing so much, like no matter what she said, they would just file it again, right? And so her calendar just, they set trial, we'd lose trial, set trial, lose trial. So I think she was just like, fine, go to the 9th. So they go to the 9th, and here's what we get out of the 9th. The Ninth Circuit on the Juliana case. Atmospheric carbon dioxide has skyrocketed to levels not seen for almost 3 million years. Copious expert evidence establishes that this unprecedented rise in CO2 levels stems from fossil fuel combustion and will wreak havoc on the Earth's climate if unchecked. This extreme heat is melting polar ice caps and may cause sea levels to rise 15 to 30 feet by 2100. The plaintiffs have exacerbated medical conditions, damaged property, and psychological harm. A substantial evidentiary record documents that the federal government has long promoted fossil fuel use, despite knowing that it can cause catastrophic climate change and that failure to change existing policy may hasten an environmental apocalypse. The problem is approaching a point of no return. Absent some action, the destabilizing climate will bury cities, spawn life-threatening natural disasters, and jeopardize critical food and water supplies. Ninth Circuit, that's what we're reading. But alas, the children's impressive case for redress must be presented to political branches of government or to the electorate at large through the ballot box. They found we didn't have standing. Right? We proved injury, we proved causation, but they said we didn't prove redressability. What they said is that nothing this court could do can redress the climate crisis. Right? That's a 3-judge panel. Josephine Staten, dissenting judge, found otherwise. She basically, this bottom quote, bottom part of the green, my colleagues throw up their hands, concluding that this case presents nothing fit for the judiciary. We're alleging constitutional claims. We've got injury, we've got causation. And she said, in the opinion, it's like, we could do something. We might not fix the whole thing, but we could make a difference. And maybe the climate crisis, if it's ever going to get this bad in 2100, maybe it won't get that bad till 2150, right? Or we can do something. We can declare a constitutional violation, and merely doing that, declaratory relief, would accomplish something. It would change something in federal policy. And I have the power as a judge to issue injunctive relief if you want, right? So 2-1 decision, we lose. But the court really was talking about our claim for injunctive relief. They didn't really talk about our claim for declaratory relief. And they dismissed the case. They didn't dismiss the case with prejudice. And so, these are some of the kids. Still hope, still hope. We move to amend, right? We'll get rid of our injunctive relief. We'll go exclusively on declaratory relief. There was a case that had come down from Justice Thomas Buzik Bonham from the Supreme Court about nominal damages that we thought demonstrated that declaratory relief is adequate relief for redressability. And so we go to Judge Aiken and we say we want to reconsider the case. I forget the exact dates, but I think we filed in, well, what date did this come out? 2023. So we filed our motion to amend in January 2021. Took her 2 years and 4 months, something like that, to rule on our motion to amend. So the case just kind of languishes, concentrations of CO2 elevate. But Judge Aiken continued to find in our favor, put us back on track to trial. But they just filed another petition for writ of mandamus, and claiming that they are suffering irreparable harm because of all the attorney time that they have to put into this. They've already put in 21,000 hours and they need another 8,000 per trial, but they thought that was irreparable harm. Joe Stiglitz, one of our Nobel laureate experts, economists, says, you know, the argument that DOJ is somehow irreparably harmed by having to spend time preparing for trial is a ludicrous argument. The true irreparable harm is the approximate cost of climate disasters or other climate economic harm since this case began, and even since the first trial of this case was stopped in October 2018. So we file declarations, all kinds of stuff saying how bad everything is. Levi, Miko, Sahara, Jacob, and on May 1st, a new 3-judge panel of the Ninth Circuit grants the petition for writ of mandamus, right? Extreme remedy. Finding, I guess, that the government has a clear right to relief. We didn't have the right to amend our complaint, which is usually within the discretion of the trial judge, right? Usually liberally granted, right? And no way. So we lose at the 9th on a 3-judge panel, and June 17th, our Children's Trust filed a petition for en banc review. At the 9th, we'll see what happens. You know,
What was the vote on the Ninth Circuit?
a 3-0. 3-0.
How many of those were Trump appointees?
All. And so, you know, I mean, all I can hope for, honestly, like, I'm trying to be like as objective as I can possibly be. I guess that's not terribly objective. But, you know, it's like this, they granted mandamus. And, you know, there's a case called Cheney versus United States that came out of the Supreme Court, talked about how mandamus is like a really, you know, don't abuse that thing. It's for very particular extreme things. And how a kid's case that hasn't even gone to trial is irreparable. It's like, go to trial, maybe you'll win. Maybe the government will win. Who knows? All right. Gang, we're 5 minutes away from the end of our scheduled time. We were late because of the other one. If any of you care to boogie out on time, that's great. I'm going to speed through to try and get to my thesis, and I'll, spoiler alert, I will tell you, Juliana is pending. It's, you know, we're at the 9th. Maybe an en banc panel says, we can't give you mandamus, and maybe we're back to our amended complaint, right? So Juliana could go. These 21 kids, relentless. Their case. Levi was 7 when we brought the case, right? He's 16 now, and by all rights, something should have changed in his life, whereas I don't want to do that anymore. Nope, they are all 21 of them, in. So Juliana could go. Held versus State of Montana. This is a state case. Same kind of case, same science. We're kids suing government under the Montana Constitution for systemic climate relief, except a couple differences. Montana has a constitutional provision that guarantees the right to a clean and healthful environment. Very specific constitutional provision. Montana also had, the case got winnowed around by, you know, claims getting dismissed and everything, and we were left with a challenge to a provision of Montana statute that said when the Department of Environmental Quality is considering a project of some sort, they cannot consider the impacts of the project on climate change. like written into law. You cannot think about climate change. And so the case became about challenging that based on that being unconstitutional. There's all these crazy great kids, Montana Constitution. This is the trial we've been waiting for. We're actually at trial in Helena, Montana, right? And so to give you a sense of what this case and all these cases will look like when they get to trial, Nan May Ellington, that lady right there, 1972, was a part of the Constitutional Convention that made the constitutional right to a clean and healthful environment. So we had May testifying to what was in the delegates' minds, what were they really trying to do? And it was a very pure, beautiful, well thought 1972, clean and healthful environment. She was awesome 50 some years later. Several of the plaintiffs testified. That little guy on the bottom there, his father is now running for governor as a Democratic candidate in Montana. Sariel talked about indigenous impacts of climate change. Ricky Held versus Montana, plaintiff, talked about the impacts on ranching. Lander and Badge talked about impacts on hunting and fishing. Eva talked about, during a flood that was occasioned by, an extreme storm, how it impacted her family for her schooling and travel times. All of them have smoke impacts, mental health impacts. These are our experts. Steve Running talked about the whole science piece of it. I'm not going to get into 1.5 degrees, but if anybody wants to talk about 1.5 or 2 degrees, let me know. Kathy Whitlock talked about impacts on the amount of rain and snow and how that's going to impact children. Dan Fagry talked about shrinking glaciers. Jack Stanford talked about surface water. Lori Byron talked about physical impacts on the kids. Lisa Van Susteren talked about the mental health impacts on these kids, climate anxiety. Mike Derglow talked about the impacts on indigenous people in Montana. Ann Hedges, another graduate of Vermont Law School, is an environmental advocate in Montana. And Ann, out of the park on her years and years of fighting environmental projects and saying, excuse me, can we consider the impacts of climate change on this project on climate change? Like, no, not allowed to talk about that. So Ann was fabulous. Pete Erickson, this is interesting stuff. He crunched numbers and came up with the total emissions in tons that Montana produces in each year, 166 million, and then looked at comparative countries, right? 166 million tons in Argentina, the Netherlands, and Pakistan also, but look at the differences in population. So we got 1.1 million people here in the United States living our United Statesian lifestyles, like eating up this stuff, and we're burning as much as these massive populations in other countries. So just disproportionate global impacts. We presented evidence through the IPCC that every ton of CO2 adds to global warming. Mark Jacobson from Stanford talked about the viability of the transition to an electrified industrial base and how it is actually doable, and all kinds of numbers if we go to wind, water, and sunlight energy. Oops. And so, we were like right on track with, the week and a half of testimony that we were supposed to have. And then it's time for the defense to put on their case, and they're like, we need a break, right? And the long and short is they put on a very poor case. The DEQ, and that's not an objective judgment. That's completely subjective. DEQ director said we're following the laws. DEQ administrator said we're not allowed to deny permits. So you're right. That's how this law that you're challenging plays out. And Terry Anderson, their economist, it was the most embarrassing and expert examination I've ever seen in my life. He said he could not do math. And
An economist.
What's that?
As an economist.
As an economist, yeah, exactly. And he, so their case in total was maybe a day and a half, right? And judge rules in our favor, like wildly. Case was over on June 25th, and August 3rd, Kathy Seeley issues her decision. It's just a district trial court in Montana State Court. Michael Gerard, director of Columbia Center for Climate, he said, I think this is the strongest decision on climate change ever issued by any court. She says, we've proven injury, disproportionately harmed by fossil fuel production. We've proven industry, we've proven injury, we've proven causation, we've proven redressability, right? A reduction in Montana's greenhouse gas emissions that results from a declaration that this limitation is unconstitutional would provide partial redress, right? And that's enough for redressability. I don't have to fix the whole problem. Like, I know you want $10 million, but I can redress you by giving you 10, right? It's not as much redress as you wanted, but it's some redress. We've proven the constitutional violation. She declared the two provisions that we were challenging as unconstitutional, and she enjoined their continued utilization. And it's now going to the Montana Supreme Court on July 10th. So that'll be live streamed on our Children's Trust Facebook page if you want to watch it. It's pretty cool. The guy who's going to be arguing, Roger Sullivan, is local counsel for us. He's like, I don't know, he probably graduated from law school in 1984 too. I was going to say he's an older guy. But he's like a poet. And he draws on, like, he's just beautiful in court. So Roger Sullivan, and that's the case, right? I mean, we put on, it's all the evidence we always knew we could put on. As I said, surely we meet preponderance of the evidence with the case they put on. It was, beyond a reasonable doubt. So that's it. The other thing is, and this is Lou's lack of PowerPoint skills at the last minute. There's also going to be a trial website where you can, if you're interested in this, you can really, you can watch all of the testimony with all of the exhibits that were used, and it's deep, but it's pretty fascinating. Genesis versus United States EPA. So this whole thing, this whole campaign is multi-jurisdictional, right? Federal courts, state courts. Talking just a quick second fast about global domestic, but like Juliana's up there, it's like it's not moving, like Ann Aiken's taking 2.5 years to rule on a motion to amend. And so we brought another case, Genesis versus US EPA, Central District of California. It's a similar case, it's constitutional in nature, but it's not all of the federal defendants, right? It's just EPA, and it's not kids around the country, it's just Central District kids. And there are a couple of interesting things happening there. First of all, they're looking for a higher level of scrutiny based on the kid's youth. Now, we all know that's generally not the way you get heightened scrutiny, but we're trying to do that. It's our kids. The court told them to, go to the political branches or go to the ballot box to get your relief. We have, like, what? Like, it's really unfathomable to me. Just give the kids a darn trial. That's what happens when you have a trial. So this case is really about EPA applying a discounting rate whenever it assesses projects or policies. And it basically says it applies like 2, 3, 4, 7, up to 7% discount rate that says a life today is worth a life today, right? This project will eliminate one life. When they apply a discounting rate of like 10%, it reaches like that one life is equal to 13,000 lives in 100 years, right? So it's devaluing the impact of these projects on kids' lives. They're discounting the impact versus what the impact is today. And we think that's wildly discriminatory against young people and their futures. So that's Genesis. Oh, there's just so many amazing statistics. The crazy thing, so Genesis, federal defendant that filed on December 10th last year. February, feds file a motion to dismiss. May 10th, court grants the motion to dismiss, citing Juliana, that just the petition for writ of mandamus. Ninth Circuit told us that you don't get redressability, we can't do this case, but we give you permission to amend, right? So we've amended the case to address the thing, the court was like, well, you didn't plead this particular thing. Okay, well, we just did. So Juliana's still alive. Genesis is still alive. There are a lot of judges out there who have given us favorable decisions. A couple in the majority, a bunch of dissenting Supreme Court justices in Alaska, in Washington, in Oregon have found in our favor, written beautiful decisions like, what are we doing, courts? The kids are claiming a constitutional violation. Just let them go to trial. Like, let's see, right? Don't dismiss the case based on what you think the evidence is going to show. These are really well-pled cases, too. Then we have Navahin v. Hawaii Department of Transportation, filed in June 2022. Trial was set for this past Monday, but it's settled. I have goosebumps all over my body right now. On June 20th. So, this is crazy. Governor of Hawaii, Josh Green, and the director of the Department of Transportation. Sorry, this case was brought against the Department of Transportation. So you see, this is a strategic campaign. We're not just filing the same case everywhere. It's like, okay, this is Hawaii. We won't have through the whole state, just DOT, right? And we'll make these little fine adjustments. And Josh Green, the governor, and the director of DOT, I don't know, saw the handwriting on the wall, read about the Montana case, saw the evidence that we're going to present here again, and they settled the case. It's really astounding. To be honest, I never thought anybody would ever settle these cases, right? For the reasons I said. And, this wasn't like a settlement where no one's happy. We're ecstatic. They've done everything. And the crux of it is that they have agreed to reduce transportation-based emissions to zero, not net zero, zero, by 2045. That's in line with the prescription for getting us down to 350 by 2100. So it's our scientific prescription being executed in this one region. And then there's all kinds of stuff. We're gonna make a youth council. We're gonna put a bunch of money into this, that, and the other thing. But we're gonna get zero emissions from transportation by 2045, and get this. And we agree to the court's continuing jurisdiction until 2045. The judge said, that's 21 years from now. We said, Judge, the attorney general said, The judge was like, well, I'm probably not going to be here, but okay. So, this is like a bellwether to me, right? So, government's fighting. OCT is fighting. OCT is what we call our children's trust. OCT is fighting. We're not going to give up. We get to trial in Montana. We won, hands down, huge, everything, perfect, right? Next case up for trial, supposed to happen last Monday, 5 days earlier. They're like, okay, we get it, right? Now, it's Hawaii. It's Josh Green. It's the director of DOT. But allow me the luxury of seeing this as, the upward trajectory of a really long fight. All the other components. There is a case in Virginia that we're awaiting decision from the Virginia Supreme Court. There is a case in Utah that has oral arguments in the Utah Supreme Court scheduled for September 4th. There's a very convoluted process going on in Florida after a court case. We're in rulemaking, Alaska, we've been to the Alaska Supreme Court twice. We just filed a third case in Alaska. Again, I hope you can see, wow, these people are any little, we're learning from what the judges are saying they are willing to do, and we're morphing the cases to address it. Canada, LaRose v. His Majesty the King, just got out of the Federal Court of Appeals, same structure, district court, U.S. District, U.S. Court of Appeals, Supreme, same thing in Canada, lost at the district court, just got a favorable decision from the Court of Appeals, so we're back ready for trial in Canada. Mexico, a little more convoluted, and India, Uganda, and Pakistan, India, is just an unbelievable situation. It's at the India Supreme Environmental Court, but it's been there for a long time. Country conditions, obviously, in these places are very different, but the crises that the plaintiffs face, both climate, cultural and otherwise, are so much more extreme. We advocate in the European Court of Human Rights, the International Tribunal for the Law of the Sea, Inter-American Court of Human Rights, filing amicus briefs, joining as interveners, all kinds of things, trying to get all of these courts to use the proper standard. The danger, gang, is that some big court says, "Oh, we're going to try and judicially order the Paris Accord, the 2-degree temperature limit." We're all going to fry. First of all, it's not a scientific prescription, right? It's like, I have a temperature. Oh, well, we'll treat the temperature. I have a temperature because I have a kidney infection. This is my problem. It's not my temperature that is the problem. It's the kidney infection. If you keep giving me aspirin to reduce my temperature, it's not going to go away, right? So that we're very fearful that the political 2-degree thing is convoluting or just ruining the real science of 350, which is necessary. So our international efforts at these international tribunals, rather than like global domestic, are based on the 350 stuff. Hawaii kids, join our mailing list. I did it in an hour. Thank you very much. Yeah.
I'm going to run for 3 o'clock work call. But quick piece of trivia showing you the reach of VLGS. There are 2 2023 law grads who are clerking for Montana Supreme Court justices. The chief and 1 other justice. I think there's 5 on that court. So,
and we've had a number of VLGS kids as law clerks. So thank you for that really important piece of trivia. Thanks, everybody.